Hi everyone. In this video, I will be outlining the Wasserstrom article about lawyers in our reading assignment this week. I hope to bring out the major points of the article. In Lawyers as Professionals, Richard Wasserstrom examines two moral criticisms of lawyers. The first criticism is that the lawyer-client relationship makes the lawyer either amoral or immoral in their dealings with people generally. The second criticism is that the lawyer-client relationship is one where the lawyer treats the client in an impersonal and paternalistic way. Incidentally, even though this article is mostly about lawyers, it is meant to highlight some issues that are relevant to other professions as well. The special and complicated relationship that professionals have with clients stems from what Wasserstrom calls their role-differentiated behavior. This is behavior that's appropriate and desirable when acting in one's role as a professional, but which may not be appropriate or desirable if one were acting in their normal position in society. To illuminate this concept of role-differentiated behavior, Wasserstrom gives a couple of examples. For instance, in the role of parent, claims of other children are less morally significant than one's own children. For a scientist, it's more important, because of their role, to expand the limits of human knowledge than it is to morally worry about how that knowledge may be used, even in harmful ways in society. In both cases, the behavior of the person in question reflects decisions that people outside the role would find morally objectionable. Similarly, the role of the professional is to prefer the interest of the client over individuals generally. So, for instance, the conventional wisdom has it that the attorney's point of view toward her or his client is appropriately different from what would be appropriate in other relationships. In fact, the author says that as long as the result is not illegal, the lawyer is essentially an amoral technician whose particular skills and knowledge are available to the client. The question the author asks in this article is whether this feature of professionalism is justifiable. Note that when the author uses the word amoral, I believe that he means it in more of its original sense than in its more recent sense, as synonymous with immoral. To be amoral is to be without morals, not to have bad ones. So an immoral person is someone who knows the difference between right and wrong, but doesn't care about what is right. The amoral person is someone who has no sense of either one. Immoral actions are, according to the website Grammarist, corrupt, unethical, sinful, or just wrong. Amoral means neither moral nor immoral, or lacking moral sensibility. So where does this idea that lawyers should be able to do anything within the law to promote the interests of their clients come from? The author believes it stems from the criminal defense lawyer-client relationship. In this setting, the job of the lawyer is not to approve or disapprove of the client's character, but rather to do everything possible to defend that client. Why? The author argues that there are a few reasons why this might be a good thing. The consequences of having one's liberty taken away is serious, and the resources of the prosecution tends to be so vast, it makes sense to give the defense counsel the job of making the best possible case for the accused. The problem is, as Wasserstrom sees it, is that while it may make sense for lawyers to act this way in the criminal defense situation, it does not justify lawyers acting in this way more generally. He believes that we may all be better off if lawyers were to see themselves less as subject to role differentiated behavior and more as subject to the demands of the moral point of view. In other words, we need less, not more professionalism in our society. Recall that the second criticism that Wasserstrom wants to make about role differentiated behavior in terms of the lawyer-client relationship is that the relationship is not typically a morally good one. The client is often not treated with respect and dignity. There are two problems that he sees here. One is that the relationship is intrinsically unequal in practice. That is, the lawyer or professional more generally is always in a position of dominance in terms of the client, and the client is in a position of dependence with respect to the professional. The author explores some reasons why this might be the case, reasons for why it probably exists. The professional has expert knowledge, uses technical language hard to understand for clients. Professionals tend to be self-regulating. The expectation is that professionals need to be objective and disinterested, and that becoming a professional is a hard thing to do. This inequality often leads to the professional acting in both a manipulative and paternalistic fashion. The client is seen and responded to more like an object than a human being, and more like a child than an adult. Wasserstrom thinks the solution may be to de-professionalize the professions. Okay. In the last part of the paper, Wasserstrom briefly discusses how this de-professionalism might occur. He says that there should be a sustained effort to simplify legal language and to make the legal process less mysterious and more directly available to lay persons. He thinks that the more fundamental changes will have to occur in the future when lawyers are educated and acculturated to see themselves and their clients in a more moral, respectful way. My apologies for the last page of the PowerPoint. Went a little haywire there. I hope this video has reinforced your understanding of this wonderful paper. Thank you for your time and attention. Bye-bye.